Hello everyone, I'm Rupinder Kaur and today we are presenting our presentation. We are four team members, me Rupinder Kaur and Gursimran Preet Kaur, Sheetal and Tushar Chaudhary. Firstly, I'm start with the introduction. Can you, Sheetal? Yeah, thank you. Is the contract law deal with the how a valid, enforceable contract with the formed and what should happen if the parties to the contract fail to perform as per promissions. Tort law deal with the duty of care that the law impose on the all us and the what happened when we breach a duty and cause personal injury and the property damage to others. In this assessment, we will discuss issue law application and conclusion of contract law and the tort law. In the first, that is the first one is the primary stopped and the agreement between friends and the family. The issue is the can Karen file a case against his brother? And the law, in the according to law, agreement between a friend and the family do not establish in the legal connection, but promisely stopped may be based in the absence of a formal contract. And in the application, Karen can use the legal doctor, doctrine of promisely estoppel in her lawsuit against her brother. In the conclusion, Karen are able to employ the legal doctrine of the promissory estoppel in her lawsuit against his brother since they had no signed a contract. Relevant case like uh, so no problem. Just move in the another second slide. The second one is the consumer data right and the ethical business practice issue. What can early parents do? Law, the Customer Data Right Rule 2020 provides the framework for how to CDR operate and the Economical Bank of the Australia, VMOD, and 1983 in the 151 CLR 447 case highlight the bank unethical behavior and the application early parents can use their right to terminate the agreement under the prevailing conditions and the translator can assist them in understanding why the bank's action were authentic. And the relevant case is the Economical Bank of the Australia via margin and 19 in the 83. It's under 550 sorry 151 CLR 447. So thank you. For the next slide, I invite my another colleague.
Hi, my name is Gursimran Preetkar and my student ID is 20173907. Today I'm going to explain two contract law questions and the first one is Angie versus Brad and Jane. And in this, there is a issue that is there any guarantee as to reasonable time for supply provided by Angie? Does Angie know about any of Brad's and Jay's potential financial losses? And the law in this case is the rule for determining the liability of the seller in such cases is the implied warranty of merchantability. Under this warranty, a seller warrants that goods sold are fit for their ordinary purpose. The warranty is breached when the goods sold are not fit for their ordinary purpose. Like if the seller breaches the implied warranty of merchantability, the buyer can sue for damages. And what is happened in this application? In this case, Brad and Jane contacted Angie to purchase a wood-fired oven for their pizza business, which is their core business. Angie promised to deliver and install the oven within 24 hours. However, due to Angie's negligence, the oven was not delivered on the time and the Brad and Jane had to close their business for 4 days. With this, they had to face a great amount of business loss and with this, Angie breached the implied warranty of merchantability by failing to deliver the oven on time, which is essential to Braid and Jane's business. So, we can conclude that Braid and Jane are having a right to sue a case against Angie for their loss of profit. And there are two relevant cases that happened. First one is Hadley versus Baxendale. And in this case, the court held that the party who breaches the contract is only liable for damages that arise naturally from the breach. And second one is Hoster versus D. La Tour. And another question related to the contract law is Gullier versus the bus company. And in this, there is issue that does Gulliver is able to sue the bus company for the full refund of his money after being injured in 23-day tour due to bus crash happen on the 12th day. In the law is that under the law of contract, a party who breaches a contract is liable to compensate the innocent party for any loss or damage resulting from the breach. And what happened in this case? Gulliver went on a planned annual holidays bus tour. It was a tour of 23 days and he enjoyed his first 11 day more than he expected. But unfortunately, a crash was happened on the 12th day of the tour, which leads to Gulliver injured so badly and he was not more able to continue his tour on the replaced bus. Due to this, Gulliver won his money refunded by the Sioux Bus Company. The bus tour company has breached its contract with Gulliver as they were not able to provide him with the agreed upon tour services for full 23-day period. And due to this, Gulliver has suffered a loss by not being able to complete the whole tour and have the full benefit of the tour services he paid for. And we can conclude Gulliver can claim damage for the loss he suffered due to the bus crash. And a relevant case to this is Jarvis versus Swans Tours Limited that was held in the 1973. And now I'm going to ask Sheetal to continue this assessment and she will explain one contract law question and one tort law question. Thank you.
Thanks. And my name is Sheetal. First is Bengals versus Amela. First is issue. Is Bengals legally entitled to go back on his promise? It is law even though he had committed to accepting the selling proceeds to satisfaction with the debt. Bengals can claim the remaining $220 from Amela under the common law stance. Then application. This is due to the doctrine of considerations which mandates that there must be mutually agreed upon transactions in which each person something of value in exchange for the other's promise, as Amela was already contractually bound to pay the full debt. She did not offer any payment for Bengal's agreement to waive legal action and accept the sale proceeds in this case. Finally, its conclusion. So Bengals can now demand the remaining $220 under the terms of the original's loan agreement, as his guarantee was not legally enforceable. And second issue is issue second, any equitable defense Amela may have to action by Bengals. Then law, despite the common law position, Amela might be able to defend herself against Bengal's claim in court and application. Amela sold her laptop based on the understanding the Bengals would accept the sale profit in fulfillment of the debt in this particular situation. Amela also suffered harm from losing her laptop, which was necessary for returning. And conclusion. So Amela might be able to use primary estoppel to bar Bengals from asking for the remaining $220. Then second question is tort law case studies. The Jane, the store owner. The store owner wishes to know whether East and Four Corner Supermarket owns a duty of care to Jean and it has breached that duty of care. Law, the supermarket is responsible for exercising responsible to protect its customer from no risk of harm. Accidents involving slips and falls are predictable in a setting where spill are frequent. And then application, the overall amount of genes damages, which include past and future out of pocket costs, income loss, and general damages for pain and suffering is $1.3 million. Gene must demonstrate that the store breaches of its duty of care resulted in her injuries to establish capability for the damages. The retailer may have violated its duty of care of to properly inspect and maintain the ISL according to the case circumstances. Conclusion: it is circular to remember that the number of damages awarded will rely on a variety of variables, including the seriousness of Jean's injuries, the extent of her agony and suffering, and how the accident affected her personal and professional life. Thanks. Next is Tusa.
Thank you, Shidal. My question is Johnny versus Ian. The issue is should Johnny be compelled to compensate Ian? The law is it's possible that Johnny won't have to pay Ian back up for the harm done to his van. This main question at hand is whether or not Johnny had a duty of care to Ian and whether or not the duty was broken. First one is it is it is unreasonable to the think that Johnny could have predict or uh, stopped the hailstorm from occurring. Second is it seems unlikely that Johnny violated his fiduciary responsibility to Ian. Because of this, he could not be required to pay Ian for the harm done to his van. The conclusion is to offset the cost of the damage. Sorry. The conclusion is to offset the cost of the damage. Ian may need to turn to his insurance to coverage or seek payment from other parties who might be responsible for the hailstorm damage. Next is Polly. The issue is if Polly were to sue Sam in the tort of negligence, would she be likely to succeed? The law is for the losses she incurred as the result of the car accident. Polly might have a compelling case to hold Sam accountable under the law of negligence. The application is the main question in this situation is whether Sam violated his obligation of care to Polly. Sam seemed to have been driving under risky circumstances and may have been going too fast for the weather and road conditions. According to the information given, the fact that Polly asked Sam to slow down shows that she was aware of the potential danger and that Sam was failing to take the necessary precautions to reduce the risk. The conclusion is this case, however, is unlikely to successful because Sam had a responsibility to modify his driving to these circumstances and to make sure Polly was safe. In her negligence lawsuit against Sam, Polly may have a chance of winning. Finally, I'm going to conclude here. In the end, we can say contract law governs the drafting and enforcement of agreements between the parties. Contract law is based on IRAC method where I stands for issue, R stands for rule law. A stands for application, C stands for conclusion. While tort law dictates how parties who have not entered into an agreement related, and it is also based on IARC method. Thank you.
Thanks, Tushar.
There are some references which are showing in screen. Thank you,
Thank
guys.
you.